Good morning. I'm Mario Joyner, Vice President and Small Business Sales Administrator for Nevada State Bank. I'd like to welcome you to today's webinar titled Insights, Key Elements of Intellectual Property. The webinar is presented by Nevada State Bank through nevadasmallbusiness.com. We are excited to have an expert on the subject of intellectual property with us today. F. Christopher Austin, partner with the Las Vegas firm of Whitey & Miller. He has spent the last 13 years helping businesses and individuals defend and protect their patents, trademarks, copyrights, and trade secrets. Welcome, Chris.
Nice to be here. Thank you.
If you have any questions for Chris, please submit them on Twitter using the hashtag NSBWebinar. Without further delay, I'll turn it over to Chris.
Very good. Well, it's nice to be here. I often get asked from clients as they come into the firm, and these are usually small businesses, what can I do to make sure that I've got what I need to have protected so that I don't have somebody come around the next day after I've come up with my new idea and start doing exactly the same thing. And there are a host of remedies that law firms can provide and that marketing people can also help out with. One of the biggest things that we talk about often is, what is it that you're really trying to do? What is the new thing that you're bringing to the market? Is it a new way of doing a particular service, or is it a new product? These are the kinds of things we first start with to get a sense of what they're doing, and then we can talk about what we might do to protect it. So I know the very first thing that comes up often is, well, what do I call my business? And oftentimes the desire, particularly of a small businessman, is I would like people to know who I am and what I'm doing. So they want the name of the business to reflect exactly what the service is. Then the classic example is if Sally comes into the office and says, I'm opening a flower shop and it's going to be around the corner or down the street. And I want everybody to know that it's a flower shop. And so she's going to put a big flower on the sign and she's going to say, my name is Sally's Flower Shop. That would be kind of the classic thing that she might want to do. And then she'll say, now can I protect that name and keep people from using that name? And my response will be, not very well. Because all of those things are descriptive of what you're doing. And they're all the kinds of things that anybody can go in and call their flower shop. And how do you prevent the other million Sallys out there who want to open a flower shop from calling their store also a Sally's Flower Shop? So far better would be to come up with a term or a name that's not immediately describing what you're doing. And gives a little bit of an essence of what it is, but not a complete description. So if you look at the great, and these are what we call trademarks, the great trademarks that are out in the world, these trademarks rarely describe the business directly. And I've talked frequently about this because it's kind of a classic example that's given to intellectual property students in law school, and it's the mark Apple. If you wanted to sell the red fruit, an apple, you could call it an apple, and everybody gets to do that. And you don't get to own that word, because technically what you're doing when you obtain a trademark is you're saying, this is a word I get to own, and I carve it away from the rest of the dictionary, and anybody who wants to use this word has to get my permission to use it. That's one, from the businessman's perspective, that's what he's trying to do. From the perspective of the consumer, they want the word, they want to know what that word means. They want to have some confidence in it. So when somebody goes and buys a computer, and that computer is an Apple product, they have a sense of where that's coming from. There's no confusion to them. They know the company. They have a sense of the kind of quality, the style, the design. All of that is built into that particular trademark. It's the goodwill that's incorporated in that mark. And that mark's a good mark because in that context, Apple means a computer company and is very different from what we generically look to as the word for a fruit, right? So I'll have this kind of same educational discussion with a new businessman coming in as I start to talk about, first, what do I call my business? And how do I distinguish myself from the thousands of others out there that might be wanting to do a similar good or a similar service to what I'm doing? So, and I'll try to help them kind of get a sense of what it is that sets them apart, and then look for some way to characterize that. So, what are the next question that often comes up is, well, okay, how do I do that? If Apple had nothing to do with computers, so how do they? You got to do a lot of marketing to kind of get that idea out there. Mm-hmm. So in the range of trademarks, you have things that we call are completely descriptive or generic. You can't use those as a trademark. Because everybody gets to use them. Okay. When you're talking about a trademark, you're talking about something that's going to exclude everybody from using it. And on the other end, you have things that are completely arbitrary. that have no meaning in and of themselves. And some of the best of the arbitrary marks are the marks that our pharmaceutical companies come up with, where they've just made it up, right, for this new product they've got. Or they've taken some of the chemical compounds there, and they know what those words mean, and they've played with them. But I think sometimes the linguists they must hire to come up with a new drug name, are just at the top of their game to come up with these words, because they got to come up with a bunch of them right down the road until they get an idea, and then they do a lot of marketing to identify what that's going to be. But so on the one end, you've got something that's very arbitrary, has nothing at all to do with the service. Yahoo, for example, has, since when did that have any meaning associated with a web search company or a service provider on that end? But then you have marks that are in the middle, and these are the ones that we call that are suggestive marks, and they give a sense of what the business does, but not directly. They don't describe it exactly, and so they lead you to think about it, but they don't exactly tell you what the work is that's going to be done. For example, if I wanted to be, in Vegas we have tribute bands, right? So we have a lot of little bands will come up and say, I'm going to be a tribute band for Queen or whatever it is going to be. And I wanted to name my tribute band Penny Lane. Okay? Now, immediately your mind will jump to who they are going to be a tribute band for, wouldn't it? Right. I know I'm going to talk about the Beatles, and probably about a particular time of the Beatles' music, because the Beatles also evolved over the course of their career. This particular tribute band sounds like they're going to focus on that more country-type style of the Beatles in the earlier years of their career, and they've picked one little phrase that came out of one song that they generated, and they're naming their band after it. And that suggests that they're going to be a Beatles band focused maybe on that particular era, without actually saying we're a Beatles tribute band, which would be almost completely non-protectable, right? Because it just describes exactly what they do.
Right.
And then the other level that we see a lot of marks in the country, but these are the most expensive in my mind to try and protect. And these are marks that we call marks of acquired secondary meaning. In other words, the mark originally was descriptive. The ones that we see all around us all the time and we don't think about, but there are hotel chains. Hilton Hotel Chain. It's named after an individual named Hilton. Marriott, named after an individual named Marriott. We can look in our own community and see Wynn, named after Steve Wynn. All of these marks are originally non-protectable because they're a description of who owns. They're nothing more than Sally's flower shop, but now it's Sally's Hotel, right? Mm-hmm. Or Hilton's Hotel, or Marriott's Hotel. But over time, people start to understand that that means a particular good, a particular service, and it acquires another meaning. It doesn't just mean Marriott's Hotel, it means that particular business of a hotel service. And people no longer associate it necessarily with an individual. They don't know who Marriott is. They don't know about his life or his characteristics or his attitudes, but they know there's a hotel named that, and that's what they associate with. So the idea being that eventually what we want for these trademarks is we want the consumer not to be deceived. We want them to say, look, I know what I'm getting because I understand what that particular word defines the service or the good I want to have. So anyway, that's on the idea, right, of what I'm called. Some of the other questions that we get asked are, well, okay, now I've got this new computer program that I want to use, and we're working on it. We're just about ready to get it to roll out, and we're going to use it for whatever particular part of the service we might have. For example, I've got maybe it's a point of sale back office type integration product that will help capture all of what the business is doing, keep track of all the data, catch additional demographic information that will help the business expand. And it's the kind of thing I could sell to a lot of retail businesses that would be very beneficial for them. It's the better mousetrap in that particular computer technology world, right? Well, how do I protect that? How do I keep people from breaking through my code, ripping it off, and selling it as theirs down the road? And this gets us into the world of a couple of things. One is we still have the trademark issue. I'm going to call it something. And then the other item is we can protect it under copyright. And that's one that a lot of people don't realize. Copyrights, like trademarks, are acquired when you first start using them, right? A trademark is acquired the minute you use it as a trademark. A copyright is acquired and you own it the minute that you or the author put it in some form other than in your own brain. So, all right, as soon as you type it on a computer, you type it into a program, or you create that code, you write it down, you type it up, whatever it is, as soon as it's outside your own brain and somebody else can look at it, it's considered to now have copyright value and you own it. To truly protect it, then you can go and register it, which will give you the ability to get damages if somebody infringes you. But I'll often encourage them to say, look, make sure to keep records of what you're doing and identify when it was that you completed the code that you've got. And then I would, for a computer code, for example, I would recommend in most cases that they seek a copyright protection, a registration from the United States Copyright Office that will help to distinguish that. And then you've got to engage in what is the next level of intellectual property, and that is using trade secrets, protecting it by encrypting it, by not letting people have access to it unless they've signed a non-disclosure agreement. So you have contractual rights to go back after them and protect it in that fashion. So these are all aspects that are fairly simple that people can do. Copyright registrations are not that difficult to obtain. There's not a substantive review at the United States Copyright Office. They're just looking that you've filled in the boxes properly on the form and you have paid the fees. There is something tricky about it a little bit if the author is, say the author is you, but you're doing it for the bank, right? Okay. So at the end of the day, the bank's going to be the one that owns that copyright, but you're going to be the author. And so on the registration, we'll identify you as the author, and then we'll identify the bank as the owner through what's called an assignment, right? Okay. And you probably, whether you knew it or not, you probably signed documents when you signed on, and when your employment records, you probably agreed that anything you create would be owned for the bank if you did it in the course of your employment, right? So if you come up with some new, better process and you write it out for how the bank ought to do something, in most cases that's going to be owned by the bank or by the employer, right?
Good to know.
Yeah, it's what we call a work for hire type thing too. So anyway, so it's usually a good idea to talk to a lawyer when you're filling that out and get comfortable with what you're doing. But if it's the kind of thing you're doing all the time, a good lawyer will teach you how to do that. And so you'll pay for it once, and then after that, if it's the same thing that you're repeatedly copywriting, I'm updating this program, I'm updating my website, then you should be able to continue to submit new copyright applications periodically as you've made those updates or significant improvements, without maybe having the lawyer review it without having to have the same expense involved. So these are things that work on those levels for many people. The next level of protection that we talk about in intellectual property is patents. And this is the one that is the kind of the sexy one that everybody focuses on, right? I've got a patent, so I'm good, I'm protected. And the classic idea is I've come up with a widget that I think is a great solution to a little problem that nobody had ever thought about before, or that it may be very, very simple. For example, just the sleeve on the coffee cup, right? To keep my hand from burning when I grab that cup. Well, somebody had to come up with that as an idea and protect it. And it's in order to protect it as a patent, I got to say, okay, this was something that nobody had ever done before, so it's got to be new, right? And it had to be fairly non-obvious. Well, and typically if it's new and nobody's ever done it before, you can pass that test, that it's not immediately obvious, right? And has a utility, has a value that's built into it. So they take that little cardboard sleeve, and they write it up in a patent, and they can go and seek to get a patent protection for it. There are a couple of ways to do that, but the one that we almost always talk about are the utility patents. These are the patents based on how the thing works in the market to help make whatever it is we're doing easier, better, faster, more efficient. That's what that's used for. So, and in that case, the functionality of the little coffee cup sleeve is that it shields my hand and insulates me from the heat of the cup. Well, somebody gets protection for that, and they can go seek a patent. And then once they've got that patent on there, they can seek to enforce that to keep others. And a lot of times, just getting the patent will try to keep others from getting into your market a little bit more. So,
you got utility versus
the other type of patent is called a design patent. Okay. And those are patents where it's not so much focused on the utility, but based on on the three-dimensional design that I've added to it, right? And you can, and there's some competition between a design patent and copyrights, but a design patent also has, it's kind of the element of a product that we do. For example, if you take a look at your iPad there, it's got a particular shape. It's got kind of a bezel around the outside edge of it. In fact, there was not too long ago, Apple won a large lawsuit based on the design element, the design patent they had for the exterior bezel shape of the original iPhone that came out. If you remember, it kind of had that rounded shape with a little silver bezel that went around the outside of it. Okay. Now, there's no functionality to that. There's an infinite universe of ideas they could have used for that bezel shape. It didn't have to be that exact radius in the curve. It could have been a different material. It could have been squared instead of rounded. All kinds of things that they could have chosen, but they chose that design. And they went to a patent firm, and they had that bezel design, just the exterior shape, protected. They didn't protect the entire shape of the phone. So if you remember, that original iPhone had kind of a curved back end, right? They just protected just that bezel shape. And recently, they succeeded in a patent lawsuit, which they brought against Samsung for infringing just that bezel design. The rest of the Samsung phone was very different, but that front bezel design, they said, was a copy of our design. And so they went after them to protect that unique design because they felt that was characteristic of what they were trying to sell at the time as their family of iPhone type products. It was part of that design. So that's a design patent. It's the thing that you put onto something that's functional or useful that in and of itself doesn't provide the functionality and is in some ways ornamental, right? Okay. That is a design that's added to it, and you can protect that. We do it all the time. I mean, we have a water bottle here with ridges on it. Well, there's no requirement for that in the functionality. It's a design, right? That I can then seek, if I want to somehow identify this water bottle as my particular brand or my bottle, I'll look for a way to protect that design, the shape of the bottle. The Coca-Cola bottle is a classic.
Yeah, those bottles I bring up.
Yeah, we could recognize that bottle immediately. It functions in many ways on several different trademark levels. It functions as a trademark in and of itself. Mm-hmm. Just that design identifies the company immediately. So it is a trademark as a design mark. It functions in its three-dimensional form as a patentable design for a design patent, right? Even the color of the glass, that the original kind of green tinted glass can be part of that. If they created new glass and added particular polymers to the glass that make it shatter resistant, less likely to chip or to cause problems with it, and something along those lines, well, they might have a utility patent based on the new invention of the glass that they put in it. So there's a host of ways to do that. It can be protected as a copyright as well, as a three-dimensional. If they'd say they had an artist come and do one, and it was done for a display, and it's a one-off, there's not many of them. In that case, it would be a copyrightable piece of art, like a sculpture, that could be protected as well. And that's the difference between a copyright that copyrights a three-dimensional object, which can be protected in copyright. That's what your art, all of your art is protected that way. Your sculptures, some of the nicer, individual products that might come out. If somebody does one large item of it, they can protect that as they make one of them. An individual might make a teddy bear or whatever, and every one's an individual teddy bear. It's not exactly the same as the previous one. I may be able to protect that in copyright because it's a piece of art in that context. When it becomes functional, then I lose some of that. Then I'm going to be looking for a design patent to protect it in its three-dimensional form. So there's a range of ways to do it. Here's a classic example, the David, right, as a sculpture. As an individual one-off sculpture, that's protected in copyright because it's a sculpture. Now, if I took that David and I replicated it and turned it into a mannequin to put clothes on, now I no longer have that there's an argument that there's no longer a copyright protection. It's now going to be a design, to some degree I'm going to look for protecting it as a design patent. If I can, I might look at it in that direction. So
makes a lot of sense. So
there's a ways to do these things to protect the interest that you have. Are there any other questions we've got that folks come up with that you put on there?
Not yet at this time,
Okay.
Chris, so we'll let you continue on, and I'm
Very
sure
good.
questions will generate.
Well, one that might come up is, okay, now I've got it. What do I do if somebody decides to start infringing me, right? This is an area that I spend a lot of time in because of all of the conventions that we have in town. For instance, in the next month here, we've got the National Hardware Show that's coming to town. Now, the National Hardware Show is an opportunity for businesses that are looking to sell products that will go into your bigger retail hardware stores, like a Lowe's or a Home Depot, something along that line, right? And so you'll have brands from anything you might find in one of those types of stores or an Ace Hardware are all going to be at the National Hardware Show. I've gone to that show almost every year for the last 5, 6 years, and invariably there is always somebody there that is knocking off one of the products that is going in there. And what happens is they'll come in. Say you'll have Stanley Tools will come in, or Black & Decker will have a display. And then right around the corner, you'll see that same wrench set or that same screwdriver set by an off-brand, frequently a Chinese company that's coming in, and they're just literally copying it and putting it out there as well. Not too long ago, I represented Briggs & Stratton, and we went to the hardware show. Their investigator, they have somebody who's full-time just to investigate what might be infringed of their products, discovered that just their very entry-level lawnmower, it's a $100 lawnmower that you would buy at even Target or Walmart, had been was right there. They could see it had exactly the same lawnmower. The only thing it was missing was it didn't say Briggs & Stratton, it said some other name, but they had copied the entire thing. Now, in the process of doing that, they had copied the patents that were associated with the engine and the structure and the way the motor works. They had copied the shroud, right, the cover that goes over the top of the mower, right down to the color. It was that bright red color as well. And they said, okay, so what can we do to stop this? And the easiest thing to do is if I can look at it and find a trademark, that's the easiest one that I can get in front of a judge to try and stop. And we looked at that shroud and discovered that, lo and behold, they had copied the embossing of the bar and diamond shape that is the Briggs & Stratton logo. So it's impressed right inside the shroud. Now they put a different name in there, utterly unrelated to Briggs & Stratton, but Briggs & Stratton had wisely protected that exterior shape as part of its logo. Right, just like Coke might protect the shape of that hourglass shape of the bottle,
right,
is protected probably in trademark for them. So we were able to take that shape, take a picture of the infringing lawnmower, go to a federal judge and say, look, they've infringed the trademark of Briggs & Stratton. We could also say, look at the entire shape of the shroud. The shroud had some kind of flaring to it here and there. There were elements of creativity that were built in the shroud. It wasn't just a box covering the motor, right? They kind of tried to make it look like the front end of a car in some ways. Had a little bit of that cowling and that kind of design element to it. Well, that's all creative. That's all intellectual property. And we call that trade dress. It's a little bit too big to try and capture with just a single word or to just draw out all by itself, but the whole of it tells you immediately that this is somebody, this belongs to them. Trade dress is an interesting concept. We'll talk more about that in a minute. But in this case, we were able to show that, and the reason trademarks are great for a judge is he can literally look. Here's the owner's trademark. Here's the infringing one. They're confusingly similar. At a minute, that's the standard. They got to be confusingly similar, right? Well, in most cases, they're identical. So it wasn't too hard to look at this exterior shape here and this exterior shape there and say, okay, they're the same. And then he can give me an order that authorizes the marshals to go down to the trade show and seize and take away the infringing product.
Interesting stuff, Chris.
So those are kind of fun.
Tell us more about protecting trade secrets.
Okay, good. Trade secrets, these are really what every business has, and they don't even sometimes realize they have them. This is the stuff that is their contacts, for example. Okay. Their particular relationships that they might have in the market, and it can be anything from my suppliers to who are my primary customers that I work with, the point of contact if I'm a business to business, and I've got a really good pricing system that's going on for one of my vendors, And it's because of my long-term relationship with one of their senior managers, and he's my point of contact. Well, I want to make sure I keep that relationship close to the vest. These are the types of things that add value to what I'm able to do, right? It also might be the types of training I do for my employees that provide them a little higher level of, we provide a little higher level of service, or a better type of service, or a different type of service than what might be found at a different company. All of these things that, as a whole, give my company an edge that are not immediately known to the world, these are the things that I want to protect. Say I'm a baker, and I've got a particular recipe for my cakes that just makes them absolutely moist and delicious, and I've inherited that. You know, I got it from my grandmother years and years ago, and then we've refined it over the years, and so it's a secret recipe that we use that provides that characteristic juiciness, I guess. I'm probably not the word for a cake, but moistness, right, for that cake that's just mouth-watering. And I want to protect that. Well, I'm not going to protect it as a copyright, because to protect it as a copyright, if I've written it down and it's my recipe, I've got to show that, right? When I submit that to the Copyright Office, it's now on display. Everybody can see it. So even though they may not open a business to compete with me, but all the little good bakers out there can just follow the recipe, and so they're not going to buy my product necessarily. And even if they do, then they may want to infringe me, and I got all this. I don't have enough money to go out and fight. All of these people are going to infringe me, so I'm better off just keeping that one secret. And everybody who works with me, they've got to keep it secret too. And this is the role of what's called a non-disclosure agreement. So when a new employee comes in to work with me, and they need to know that recipe in order to do the batches for me and to help build it, they're going to sign an agreement that says, I will keep this trade secret, and I will keep it a secret forever. Trade secrets can be protected forever, in perpetuity. There's no limit on that. Now, other things you're going to have an expiration, but a trade secret can be maintained forever. And we see that, for example, in the classic Coke recipe, right? Nobody technically knows what that recipe is, or years ago, or even now, Mrs. Fields' cookie recipe. It's a secret recipe. Those are the ones that are obvious that we think of. But your pharmaceutical companies have hosts of these, where they're going to try and keep certain things close to the vest as a trade secret as much as they can. Once they will then go through another process, and they will ultimately patent those. Once they do that, it's now public domain, right? Everybody can look at the patent, and it will expire. So they've got a finite number of years to maximize what they can make off that drug.
Then here comes the generics.
Then the generics come along, who
right.
are literally copying the patent,
right.
the recipe, as it were, right, and doing it. But if I don't have to do that, then I've got, and they have to do that for the regulatory reasons in the industry. But if I don't have to do that for my cookie recipe, for my cupcake recipe, or for whatever it is that I've got as my particular good service idea that I've come up with, or a new way of just heating or cooling a building. It could be anything that you could come up with that I may want to protect in trade secret if I don't have a good way to protect it in any other way.
So how does that conversation go? I'm thinking of some clients that fit the description in which you just described, in terms of counseling them between whether or not to make the step and make it public, or whether to keep that private. How do those conversations go?
Yeah, it depends on what you're looking for. Is the thing itself the thing I'm selling, right? So if it is something I'm selling and it can be reverse engineered, right, then I'm not going to be able to protect it very well as a trade secret, because they can take it and undo it and rewind it and figure it out. So in that case, I'm going to try probably and protect it as a patent if I can in some fashion.
Okay. Right.
So I'm going to look and see if I will qualify as a patent, if it's something that can be undone right in front of me. If it's so that's probably the first answer, right? Computer code, for example, you can come up with some great computer code, but if I've got if in most cases when you sell that code, you're not selling the code, you're selling a license to use the code. You own it, right? So when you buy a computer program, you're actually not buying the program, you're buying a license to use it. And that's most likely protected in copyright.
So if you're discussing a project or an idea with someone, this is me, Joe Public.
Yeah.
How can I be sure that they won't steal my ideas?
Yeah, that's a tough one. There's no way to know for sure they won't steal your ideas. the best you can do is try to protect those ideas from being stolen, or make it very difficult for them to go forward and try and infringe you as you go forward. So the thing to do right off the gate is to try and make sure I've got the protections I can in place. They don't cost very much to do. So I want to identify this as my stuff. So make sure I've got a mark on there that says this is my businesses that owns this. This is my product. I've trademarked to this name. And then the next thing I'm going to do is look at what it is I'm doing. So if it's something I can protect in copyright, if it's something that's written, something that's got an author associated with it, then that's going to be copyright protectable. I'll want to make sure if it's the thing I'm actually selling, people are going to buy that, or they're going to buy a license to use it. I'll want to get that registered, so I can have an official U.S. copyright registration on that, which will help kind of put people on notice. Even if I don't do that, you can still indicate on that document the minute you create it, because as we talked about earlier, you own it the minute it leaves your brain, right? So at that point, I'll still put on there copyrighted and a date indicating that it's copyrighted and to who it's copyrighted to, whoever that owns it. The distinction between something that's copyrighted under common law, because I created it, and something that's registered is that Circle C. So once I register it, I get to use that Circle C, right? And the same is true for trademarks. Once I've registered something as a trademark, then I can use that Circle R as a registered trademark. Right. Until I register it, it's still my trademark. I'm using it, right? I've named, instead of Sally's Flower Shop, she came and talked to a trademark attorney, and she talked to a marketing person, and she came up with a new name, and she's going to call her flower shop, sunflowers on the corner, or something, right? So she's come up with a name that's got a little more descriptive. It's got some suggestiveness to it, right? People get the sense, oh, it's sunflowers on the corner, and that brings to mind a bright spot, maybe a garden spot on the corner, but in fact it's her flower shop. So she's going to want to put that mark out there and start using it. Well, the minute she starts using that as her trademark, she can put a TM, a capital TM, by that trademark, even though it's not registered. Once she registers it, then she can do that Circle R to indicate that it's now a registered trademark as well. And these are all little things that help people know we're serious about protecting the intellectual property that we have. And what is that intellectual property? It's my ideas, it's my creativity, it's the stuff that sets me apart and adds value in the community I'm in, or in the world I'm in the business world that I'm in. It's what we would call the goodwill of the company that gets built into that, right? It's the reputation. All of that get built into the trademark, or into the underlying good that I've got that I'm putting forth, or the service that I'm doing.
So as a follow-up, what happens if two people have the same or nearly the same type of written work or an idea? Who is considered the owner of that intellectual property? Good question. This raises a good issue in copyright. Because copyright, the first person, you own the copyright the minute that you put it in tangible form, right, as I talked about, or it leaves your brain. Right. Somebody else, theoretically, although it's very unusual, could do the same thing at the same time, right? Mm-hmm. And there is a priority, so whoever came up with this and put it out, and it's theirs, they would own it, and so would the other person. So the real challenge is I've got to show that these two things that look really similar, right? So maybe I got two stories that have come out, two books or whatever, or two articles that have come out, and they look really similar. But if both can say, look, I independently created this, then they both can survive independently. It's only if it looks like one was copied. Thus the copyright protection. I'm protecting it from being copied. You don't get to copy my idea or copy my words as they're written down. So you've got to, in that context, you've got to show, if you're going to prove that somebody has violated your copyright, you've got to show they had an opportunity to copy you. Well, how would what's the easiest way to show that they had that opportunity? You registered your copyright and stored it with the United States Copyright Office. It's now in the public domain. So from that date forward, the thing I wrote is in the public eye. And presumably, anything that is like it, that comes after that date that I published it and put it out there, well, you had access to.
And so you could have copied it.
Sticking with that theme, does an author have to register as a business in order to protect the intellectual property?
No. Intellectual property can be owned by individuals or by a business.
Okay.
So it can be owned by either. Often it's owned by the individual first. The example of the author who writes a book or writes something or puts an article on a website, right? That's an individual wrote that, and they're going to own that original copyright because they're the author. And then they can assign it. They might be required to assign it by their employment contract to the company, and they'll sign those rights to the company in that context, or they'll sign it to their own company because they want the company to hold those rights, to build the equity in the company, build the goodwill in the company. And that also comes down to, what do I want this company to do? What's my end game? And this is the kind of discussion that bankers get into as these companies are trying to get funded and financed. What's your end game here? Are you planning on expanding and becoming a major player, or are you looking to fit a niche that then another larger company might come in and want to buy you out?
Now, what can I call my business or product? Do you have any best practices as that's related?
Yeah, this is one of those where if you can bring your marketing person with you, and if you've got somebody there or you've talked to one, that's a good conversation to have, because it really requires that I understand what it is you're trying to do, the essence of your company. So going back to our Sally's, flower shop, if Sally comes into my office and I just kind of came up with the name, and we'll call it, Sunflowers on the Corner, that might be a really good name if that's the kind of a business that she is. So if we go and we look at her business and we see what she's really about, and she's not really about the formal type roses and bouquet type stuff. She's more about the country, the provincial type of style, where it's more wildflowers. That's kind of what she's about, and that's the style that she's got in her store. Well, then that's why we might come up with something like Sunflowers, as a way of giving an essence of what she's about without necessarily describing directly. And this goes back to what I think is this is marketing according to Chris Austin in the context of trying to protect your rights. I think these suggestive marks, they give a little hint, but are not direct, are a good start for a smaller business. The real challenge for a smaller business is they're going to want to call it, then they're going to pressure me. I've got to call it Sally's Flower Shop, or nobody is going to know it's my business, right? I've got to make my name my advertisement. And I will continue to counsel them, no, you really don't, because down the road, once you become big enough, you'll have no way to protect that name.
So I know a lot of businesses, they don't think beyond this one store, an example of your Sally's Flower Shop. So if I'm thinking about naming my company, business, should I give thought to how large I want to become, whether franchising is an option, if I want to have multiple locations, do I want to have my name involved in that, in the business itself? Are those the kinds of questions that also are raised when you have consultations? Yeah,
they will come up. I mean, it depends a lot on what kind of business it is. Say I'm putting together a little daycare center, and I want that daycare center is going to have a certain quality to it. Here in Las Vegas and in the Southwest generally, these are going to need to have nice indoor space, so that during the summertime the kids have a place to play that's comfortable and clean and is well supervised. So I'm going to want, and you got to put those close to where the families are that are going to need to use that service. So it's likely I'm going to want to build them in many of the little communities all around the valley. So I'll want to have one here in Henderson. I'll want to have one in the Summerlin area, one in maybe towards the Boulder City area, maybe one in Northtown. I'm going to put these regionally close to where the families are, so I can anticipate there's a likelihood if this goes well, I'm going to build more of them. Well, what's going to then make it clear to the neighbor that learns of it from Henderson, but then leaves and moves to Summerlin, that's the business. I want that. That was a great little business there, that little daycare center that was in Henderson. I wonder if there's one in Summerlin, right, if I move out in that direction. And the thing that's going to set that apart is going to be that trademark. Initially, that's going to be the thing that's going to help me understand it. So I'm going to want a trademark that I can continue to use as I go from place to place. Now that mark can be anything, like we've talked about before, as long as it doesn't specifically describe this thing they're doing. So it can't be, Mrs. Smith's daycare center. You know, he's going to have to be something more than something less descriptive than that. And they'll come up with that. That builds into it a certain level of comfort and quality so that people who have heard about it by word of mouth or by advertising, when they see another one in a different location, they already have a sense of what that is before they walk in the door. It's kind of like McDonald's. I know what the McDonald's is going to be like, right, whether I'm in Shanghai or I'm in Duluth. It's going to be the same.
Right.
And that because they've been very good at maintaining that kind of level of service and quality in each place, and that all gets built into that trademark, so I know what I'm looking for. So yeah, you do think about those things. We talked briefly about the idea of a name, and we've talked about how you can protect the name. If you are a professional service, like I am, I'm the name of my firm, and it's an intellectual property firm. The name of my firm is literally the name of the two founding partners, right? Whiting and Miller.
Right.
So that is because, in a professional context, the service is specifically identified with the individual providing it. So you're looking for a particular doctor, you know the doctor by name that does a really good service that you're looking for, right? Or the dentist. This is the dentist I recommend. You know, Dr. George is great. I'm going to go to him because he's done a great service for me in the past, or whoever that's going to be. And you're going to, and it is built into that name. Your performers. We also are involved in the intellectual property, representation world. We get involved with people who are in the media, and their name, what we call their rights of publicity, is like a trademark to them. It's built right in. And that is also the case for your professionals who provide those types of services. It's built into their name. So they'll build rights in that name as they go forward. Now, over time, like a law firm, there can be those two founding members whose names form the company. As they continue to bring others on, and as time goes on, the firm gains its own reputation based on the quality, the training, the types of services that are provided. And so the name then becomes less associated with the original founders and more associated with, oh, that's the intellectual boutique firm that's got these, got great attorneys, that's what I want people to say, right? That got great attorneys that know what they're doing, that can help protect my intellectual property or whatever the service is that's going to be done.
So besides calling and engaging you immediately, what should I do if someone steals my intellectual property?
Well, I would document it right away. Okay. Keep track of what it is they're doing. Keep track of what their connection to you is. So if they're stealing it and you've never heard of them before, that's different than if they were your supplier at one point in time, right? Because most likely, if they're somewhere in the chain of your business, they're a supplier, a vendor, a former employee, a manufacturer, whatever they are, hopefully you will have had them sign that non-disclosure agreement, or that something along those lines, or an agreement that, in addition to the protections that you've got under registering your trademark or your copyright, you've got contractual protections that you can go after them for as well. So these are all, and that will give you some quick remedies. In any of these cases, let me just kind of make this really clear. Intellectual property is a unique element of property, and as a result, anytime somebody infringes it or steals it or takes it, because it deals with what we were talking about here, this goodwill, this reputation, that's not tangible. How do I figure out how much my damage is, right? You've come along and you've stolen my trademark, and you're using it, and people think you're me out there in the world. But you're not me, and so every time you're out there working, you're doing something, you're not building my reputation, you're building yours, or you're destroying mine if your service doesn't match to mine. That damage is what we call irreparable. There's no way to put a dollar figure on it easily, right? It's not like I can count up the number of widgets that you stole out of my store. I don't know what the actual value of this is over the course of my business. Because of that, the law gives a particular special remedy. And that allows me as a lawyer to go into the court and say, right now, before we have a whole trial, right now, judge, stop it. Order it to be stopped. Order them to stop the infringing activity. Order them to take that infringing trademark off their good or off their building. And I can get that done. In most other cases, that's very difficult to do. But in the world of intellectual property, we can almost always get that accomplished if we can show clearly that there's infringement that's taking place.
It's not uncommon, I was thinking about when you're talking about former employees, but it's not uncommon to see a subset of employees start a business that take advantage of the skill sets they've learned and things. How, as an employer, how can I protect them from taking clients away and other, to me, cultural benefits? What can I do from that perspective? There's
some things that you can do. These come back to that employment contract that you will have signed when you came on board, right? We all signed these when we came on board as employees at one point in time. Number one, you can make sure they can't take anything that is trade secret, right? That's kind of the golden rule. We start with that. Anything that I qualify as trade secret doesn't go out the door. Well, I've got to make sure I clearly identify the stuff that's trade secret too. So my employee later on can't claim and say, well, I didn't know that was a trade secret. Well, yeah, you did, because it was on your employee manual listed as confidential. And I put that confidential right on there, or I wrote trade secret on there. You know, so any place I've got it in a format, that's what I'm identifying it as. So it requires a little bit of you know, diligence and pre-planning on the part of the business to keep track of the stuff that's really important. But most businesses have a sense of what's really critical to keep us competitive. That secret recipe, it's going to have trade secret on there, and it's going to be locked in some fashion, right? Used to be in a safe under a special combination or key. Now it's under an encryption in the company's server, and that's what you're going to do. You're going to keep that set aside. The next thing you're going to do as part of that employment contract is you're going to have something on there that limits what they can do when they leave your employ. Okay. And they look at that right out the gate. Now, these are what we would call limitations on your ability to go out and compete. So they're non-competition agreements that you can put in there. There are limitations from jurisdiction to jurisdiction on how long as a matter of public policy, that any state or location is going to let you do that. So in Nevada, for example, it's about a 2-year limit that they're going to let you do that. But it's a balance between how long you don't get to compete, or geographically what area you're not going to get to compete in. Okay. Right? If my geographical area is larger, then the duration of time I can prevent that person from competing against me is going to be smaller. Got it. The policy issue is, well, I don't want to prevent somebody who's got that specialty from not being able to have a job. Right. You know, or having to move to a great distance away. So there's going to be a limitation in that respect.
Well, let's circle back to some of the patent. So another patent question. Is it only enforceable here in the U.S.? Does it extend beyond our borders?
It can extend. You can get what are called international patent rights as well. And those are very important. If you are looking at a product or service that you expect will be sold outside the United States or shipped to or exported. If you're concerned about people bringing it in and competing against you just in the United States, this is your market, right? I represented a company called Bond, and their market is the United States. They, for the most part, and Canada. They produce outdoor, kind of high-end patio heating equipment and fire pits. Well, look at the world. Who has the backyards to put nice heaters in them and fire pits and to have these big, expansive backdoor living spaces, which is what all of this furniture is designed for? It's not really in Africa or China, not even in Europe. It's really kind of exclusively North America that has that kind of style of living. So that is their market that they're going to focus on. Now they may also go get international patents, and they do. But I would look at the business model, because it's more expensive to go and get these international patents. I would want to take a sense and say, okay, where is this going to go? If it looks like it's something that I want to get protection internationally, you'll want to do that right out of the gate. You'll need to file that fairly soon after you begin the process of seeking a patent in the United States, because there are limitations in time that start to kick in for when you need to make those applications.
So it's a good idea to look at this if I have my production, say in China or in some other country where they're actually producing my good or service. Is that at the time I want to look outside the U.S. for protections?
Yeah, if I'm using an overseas manufacturer, I'll want to get protections as much as I can in that country, as well as in the country where I expect the product is going to be sold. Got it. Yeah. And in those cases, you're going to need the expertise of patent attorneys, because you'll need them in both jurisdictions to be able to appear before the court, or the patent offices, the respective patent offices in those two countries, to get them filed and granted.
And in terms of just Nevada laws, how helpful are they regarding trademarks?
Nevada's trademark law is great. In Nevada, there's not what we call a substantive review of your trademark. Okay. What that means is, just to give you the contrast, if you apply for a trademark before the United States Patent and Trademark Office, you'll send that application in, and an attorney at that office is going to evaluate whether or not you qualify for a trademark. And they might reject you, or they might preliminarily reject you and send it back and say, you've got to give us this additional information, or you need to make these changes. And so there can be some give and take until you negotiate your way to getting that trademark approved. And that's a fairly normal process. It's another reason why trademark attorneys are sometimes a necessary evil, I guess, as it were, if you're going to get a trademark through the United States Patent and Trademark Office and you're really trying to get broad coverage. Not in Nevada. In Nevada, if nobody else has taken that word, it's like trying to get my business name. If nobody else is using it, then then it's mine. And I pay the fees and I fill out the form, it's mine. And I still get all those presumptive rights that it's my trademark. You've got to show a reason why you qualify, or that your mark or your idea came up before mine in order to try and defeat me. But I have the presumptive trademark rights in Nevada by having done that. And it's a fairly nominal fee. I always, if you're going to be starting your business here, get that trademark registration. It's not a hard thing to do. Fill out the form, submit it, get it in. If it's, I would still talk to a lawyer to make sure I've got truly a trademark that can be protected. I'm not registering, because the downside is Sally's Flower Shop could be registered in Nevada, right? But as a matter of trademark law, it has almost no trademark protection, so I can't really enforce it if I have to, because it's not really a trademark under the law. So that's why I would go come in, and we'll come up with something like we talked about, sunflowers on the corner, and that we go get registered with the state of Nevada, and at a minimum that gets us this area. And then if she's going to start exporting out to the other states or to people who can get on her website and order flowers and they really like what she's doing, or she starts doing dried flower arrangements as well and they can be shipped, well, now she's now doing business beyond this little geographical area. And almost every business anymore does that because of the website presence that they've got. And so the idea of registering federally is almost a default. I've got to do that as well if I'm going to be in any fashion marketing beyond the borders of the state.
Great segue, talking about websites. So if I set up a website, how do I protect people from copying what's on it?
Good. Yeah, and that's the same thing. This is your copyright protections. Make sure you've got on your website, like we talked about before, copyrighted, and the date and the name of the company that it's copyrighted to, so that you can clearly identify that it's there. And then it's a matter of deciding whether I'm going to, like I said, we can go get that copyright registered. If I have it just copyrighted, that won't let me get into court to enforce it. I've got to go get the registration, or at least apply for the registration. We call that the ticket to the courthouse. So once I've put my website up, and then I look around the corner, I say, oh my gosh, somebody has taken my whole design. I had this really cool design that I put out there, and I hired a graphic designer to put it together, and somebody else has taken that exact same design, not even the words, just the design itself, right, that they've done. Well, that's all copyright protected. So at that point, then I'll file that with, if they came in and talked to me, we would immediately file an application for a copyright with the Copyright Office, and then we can begin a legal process against them. If we wanted to go and file a suit against them, often it will resolve. Most of these resolve once an attorney gets involved and sends off what we call that cease and desist letter that says, look, we see you've got a design here that's exactly the same as our clients. It was a web design available to everybody, so we know you had access to it, and it looks like you've copied it. That violates the U.S. copyright laws, and it has as a damage attached to it, if we prevail, up to $150,000 statutory damage. I don't have to prove any harm at all. Just show that you maliciously copied my stuff. Do you want to do that, or do you want to just take it down? Right? And that's the kind of thing that we'll send out initially to try and resolve it. And if that doesn't work, then unfortunately we may have to file that suit. And that's one part of it. The other thing that we can do too, now that we're talking about websites, I can also go to to the host that's hosting their website, and under other international laws that deal with what are called the UDRP rules, I can issue a complaint and say, look, that website is copying my content. I want you to issue an order that they stand down or take it down. I want a takedown order on that website to take the whole website down. And under that regime, which is a separate process, an administrative process, that can be very effective at they'll go in and give that that website a little warning that says, look, we just received a complaint that your stuff is infringing this other copyright. Provide documentation to show that it's otherwise, or we will be taking it down. There's a process that's involved, and that can even be faster than trying to go through a legal process.
So do you make the determination of which direction you want to go, or is there a protocol? Do you typically start with that company and then work towards the hosting company, or do you have either avenue?
Yeah, I will typically try to resolve that informally and as cheaply as possible for the client. That's usually their interest, right?
Right.
So that typically is a phone call or a letter first, before we really get into having to do some formal legal documentation that's going to cost you a lot more money. So then we'll look at the nature of the infringing activity to see whether a UDRP process would be better, or a federal court route might be better.
Well, as we wrap up, last question: how do I prevent others from using my name?
Yeah. Your trademark in this case, so they don't infringe your trademark. And it's kind of the same thing, same kind of a process. If I find somebody that's using my trademark, my initial response is going to be, look, I need you to stop. I'll send a letter off, make a phone call, see what we can do to get them to understand they need to take that down. We have these kinds of, so that happens. That's one way to do it. And then again, if that doesn't prevail, then I have a couple of other options, right? I can also, it depends what they're doing. If they're just infringing my mark, then I'm going to have to go the court route to try and get them to stop. If they're trying to register their own trademark with the U.S. Patent and Trademark Office, and I think their mark is too close to mine, too similar for similar types of goods and services, well, I can join into that process and submit documentation to the Trademark Office in what's called either an opposition to their application, or I can seek to cancel their registration if they got it registered and try to prevent their mark from getting issued from the Trademark Office as well. So there's other alternatives, and it's impossible to say right out the gate which one's going to be the appropriate one in every context. It really depends on the nature of what that business is trying to do and how much time we have, or whether the issue is the trademark or whether the issue is the goods and services that are being sold under that trademark. What we're going to focus on as a remedy to try and stop that. But in every case, we'll try to stop it as inexpensively as we can first, before elevating it to the next level to try and take it out.
Well, I've certainly enjoyed the information. I found it very informative, and also I can apply this. I was able to follow you and the logic behind your comments and thoughts. But just to know, in concluding, if you had any final comments before we wrap up.
Sure. I guess my last comment would be, as a small business and you're getting going on one of these things, and you're going to start a new process, take the time to think through, what is it that's going to set me aside from everybody else that's out there? What is it that's my particular niche? Mm-hmm. The service I provide, the good I provide, and let's make sure that we've identified, if I have to write them down, here's what they are. And whether you identify them as a trademark, a trade secret, or a copyright, that may be less important, and I'm not expecting, and nobody expects anybody to keep track of all of those things, right. But identify, this is what we do that's cool. This is what we do that's better. Mm-hmm. This is the thing we provide that's new and that solves a problem, and list those things out, and then make sure across that list you've identified a way to protect them. And if you walk into my office with that list, we can certainly show you, and so can any of the other intellectual property attorneys in this town. Best of luck to you in your new business.
Well, on behalf of Nevada State Bank, I'd like to thank Chris for presenting this valuable information.
My pleasure.
We hope you can apply some of these ideas to help your business succeed. And thank you to everyone who participated, especially those who submitted questions via Twitter. If your questions was not answered today, we'll send you an answer in the next few days. If you'd like to see the webinar again or invite others to see it, a recorded version will be available later today on nevadasmallbusiness.com. I'd also like to invite you to register for the next webinar in the Insights series, which will air on July 15th. It will feature legal experts discussing ways your business can reduce the risk of litigation. You can register at www.nsbank.com/webinar. We will also have a webinar on June 12th, designed especially for family-owned businesses. The focus of this webinar will be on performance expectations, evaluation, and compensation. You can register for it at www.nsbank.com/familybusiness. This webpage also contains links to other family business webinars and our free family-owned business newsletter. Thanks again for participating and have a great day.